If you've been named the executor of a parent's estate, there's something I want you to know before you do anything else. First of all, welcome. I know you didn't ask for this. You weren't trained for it. And right now, you're being asked to make six-figure financial decisions in a legal process you've probably never been through while you're still grieving. That is an enormous amount to carry. In this video, I want to give you 3 things to do first, not because they're the only things, but because they're the ones that protect you from the mistakes that cost executors the most: time, money, and family conflict. Before you call a real estate agent, before you respond to any investor who's reached out, before you touch anything in that house, do these 3 things. Before we get into it, if you've been named personal representative of a Massachusetts estate and you're not sure where to start, comment guide and I'll send you my free executor's guide. If you're already past step 1 and you're trying to figure out what the property is actually worth before you make any decisions, I can help with that. I offer a free conversation specifically for estate executors where we look at the property, what it would realistically sell for in today's market, and what your options actually are. The link is in the description. No pressure, just information. I'm Alexandra Dertouzos with RE/MAX Executive Realty. I specialize in estate sales and probate listings in the greater Boston area, and I've been doing this for over 20 years. I've also been a real estate investor for more than 3 decades, which means I've been on both sides of the calls you're probably getting right now. I know what executors need, and I know what the other side is counting on you not knowing. Okay, let's talk about the 3 steps. These 3 steps are what I walk every estate family through before we do anything else. Step 1. Certified death certificates. The first thing you need, and this sounds simple, but it's where people lose weeks, is an adequate number of certified copies of the death certificate. Not photocopies, certified copies, the ones with the raised seal or the state-issued security paper. Here's why this matters. Almost every institution you'll deal with in settling this estate is going to ask for an original. The bank, the mortgage servicer, the probate court, the registry of deeds, the insurance company. You hand these out one by one, and you can't get them back. Most people think they need 2 or 3. In my experience, for an estate with a property, you want at least 8 to 10, sometimes more if there are multiple financial accounts, a reverse mortgage, or a life insurance policy involved. I personally ordered 10 when I was the personal representative for my mother's estate. You order certified copies through the city or town where your parent passed away. In Massachusetts, that's the local city or town clerk's office. You can also order them through the funeral home when making arrangements after their passing, which is usually the easiest route. Each copy costs a small fee, currently around $15 to $20 in most Massachusetts municipalities. It's worth every cent to have them in hand before you need them, and it's better to have extras than not enough. Don't wait on this. The moment you're short a death certificate, a process that should take days turns into weeks. Step 2, probate. Which path are you on? The second step is understanding your probate situation, because not every estate goes through the same process, and the path your estate takes will directly affect how and when you can sell the property. In Massachusetts, whether probate is required depends on how the property was titled. If your parent owned the home solely in their name, no joint tenancy, no designated beneficiary arrangement, then yes, you'll almost certainly need to go through the probate court before you can transfer title. Massachusetts uses what's called the Uniform Probate Code. There are 2 main paths, informal versus probate. The first is informal probate. This is the more streamlined process, and it's available when there's a valid will and the heirs are in agreement. You file with the probate court, you're formally appointed as personal representative, that's the Massachusetts term for executor, and you receive letters testamentary. That document is what gives you the legal authority to act on behalf of the estate, to sign a listing agreement, to accept an offer, and transfer the deed. The second path is formal probate. This is required when there's no will, when there are disputes among heirs, or when the court needs to be more actively involved. It takes longer and typically requires an attorney. Here's the question I get asked more than any other at this stage. Can you list the property before probate is complete? In Massachusetts, it depends. You can prepare the property and even accept an offer, but you generally cannot sign a listing agreement or close on the sale until the court has formally appointed a personal representative and issued letters testamentary. An experienced estate attorney and an agent who understands probate sales can help you sequence this correctly so you're not losing weeks waiting when you don't have to. My strong recommendation is to get an estate attorney involved early, even one consultation, to map out your specific situation. It's worth it. They'll tell you exactly which path you're on and what the realistic timeline looks like. Step 3, check for a reverse mortgage or equity tap. This is the step that catches executors off guard the most, and it can have the biggest financial consequences if you miss it. If your parent was 62 or older, there's a real possibility they took out a reverse mortgage on that property at some point. Reverse mortgages, also called home equity conversion mortgages, or HECMs, allow homeowners to borrow against their home equity without making monthly payments. The loan balance grows over time, and the full amount becomes due when the homeowner passes away. As executor, you typically have about 6 months from the date of death to either sell the property or pay off the reverse mortgage balance. In some cases, you can request an extension, but the clock is running from day one, and the servicer will move towards foreclosure if the loan isn't resolved. This is not a situation where you want to discover it later. Less common, but also possible, is that there may be a home equity tap on the property. So how do you find out if one of these exists? First, go through your parents' paperwork, loan documents, statements, anything from a mortgage servicer. If you have access to the property, check the mail. Reverse mortgage servicers send monthly statements. You can also check with the Registry of Deeds in the county where the property is located. Mortgages are public records searchable by property address. This is the best way to see if there's something you need to be aware of. If there is a reverse mortgage, contact the servicer immediately. Let them know you are the executor. They will tell you the current payoff balance and the timeline. That balance needs to factor into how you think about any offer, because you're not netting the full sale price. You're netting the sale price minus whatever is owed on that loan. This is also one of the reasons investor offers on estate properties can be so damaging. An executor who doesn't know a reverse mortgage exists or who doesn't know how to calculate what the estate will actually net is actually the person those offers are designed for. You deserve to know the full picture before you sign anything. So to recap, get enough certified copies of the death certificate, more than you think you'll need. Understand which probate path you're on, and check for a reverse mortgage before you make any decisions about the property. These 3 steps don't require you to know everything about real estate or estate law. They just protect you from the mistakes that cost executors the most in time, money, and in family relationships. In the next video, I'm going to answer the question I get from executors more than any other. Should you take the investor's cash offer or list the property on the open market? I'm going to give you the honest answer, including the situations where a quick close actually makes sense and the ones where it doesn't. That video is linked right here. So if you've been named personal representative of a Massachusetts estate and you're not sure where to start, comment guide for my free executors guide and I'll send it to you. If you're trying to figure out what the property is worth, before you respond to anyone, that's exactly the conversation I have most often with families in this situation. It's free, it's specific to your property and your circumstances, and there is no obligation. The link to reach me is in the description below. If this video helped, please subscribe. I make content specifically for executors and estate families navigating this process in the greater Boston area, and I want you to have the information you need before anyone else gets to you first. I'm Alexandra Dertouzos with RE/MAX Executive Realty. Thank you for being here. I know it's a lot to be going through.